Today is our podcast with me, Merrill Catlin from Make It Tea Online, and Guillermo Ione from Make It Tea Online, and with our very special guest, L.A Perkins, who is a brand attorney. And we are so excited to be talking to her. And we're going to ask her a million questions, but I want to thank you, friends, for joining us on Spill the Tea today. And we hope that you get some value out of our podcast. The purpose of Spill the Tea is for us to get behind the seams of the apparel industry, printing, clothing, material, and everything that's possible with apparel. So are we ready to spill the tea with L.A. Perkins? Boom, 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 boom.
Thank you so much for having me. It's great to be here with both of you.
We are really excited. Guillermo and I have been talking about this interview and questions we're going to be asking you, and we put out to our audience if they have any questions. So we have a couple questions that people have asked, and hopefully we will get them answered. But first, let's get to know a little bit about you. So go ahead, L.A.
Wow. Well, there's a lot I can say. I'm a lawyer in the state of Florida, and my office is actually located in Boca Raton. I have been practicing for almost 30 years, and I started out in large law firms, and I became a partner in 2 large law firms before I went out and started my own law firm about 10 years ago. I'm a total entrepreneur at heart, so I love talking to other entrepreneurs because since a very young age, I've been interested in business, watching my father in his business as a child. And then even when I was in college, I set up my first businesses. And now that, I do what I do, I can see all the things that I did wrong, like, ignorance is bliss. And so that's what I do now. And my focus, as you said, Merrill, is on, I'm a brand protection attorney, which is also intellectual property. I help my business owners and entrepreneurs identify and protect their intellectual property assets and enforce those rights when they need to, so they can avoid costly mistakes and increase the value of their businesses. And that's, what my passion is and my focus is. A little bit about me on a personal level. I'm originally from South Africa, and I moved to the United States in 1977 with my family. And I became an American citizen in the largest naturalization ceremony in the history of the United States, which was in 1986 in the Orange Bowl in Miami.
Oh,
wow.
Tell me a little bit about your name. LA is catchy for me. I would like to know more.
Well, that came about. It turned early on in my practice. My ex-husband, when we were dating, he created a nickname for me, and that was LA. And I didn't even know that he had created that nickname. And I heard another friend refer to me as LA. I was like, LA? Okay, I kind of like that. And at the time, LA law was really popular. And when the other lawyers in the law firm I was working at heard LA, it just stuck. Everybody's like, we love that. So it became LA. And it's worked really well for me as a personal trademark, so to speak.
Nice.
So you are your own brand.
Yeah.
Yes, I am. Exactly.
Right. So when your father had his business and you started out as a young entrepreneur, did you see that having like a certain brand protection is valuable? Was there anything that was working then that caused you to choose this form of law?
So that's a really good question. And because I've reflected on that recently, as I'm actually writing a book on the importance of brand protection, and I was reflecting on where it all came from, like my desire, my interest. And I can tell you as a child, I didn't think, is your brand protected? But what I did think was, wow, that branding is interesting. That logo is interesting. And I would like look at packages and be fascinated and think, what's drawing me to this package? And that's actually had me when I went to college. I ended up getting a degree from the University of Miami in Florida, a degree in international finance and marketing. So marketing, it's like been a natural fit for me to do what I do. I mean, when I first started out, very initially, I didn't do intellectual property, but I knew I wanted to, it's where I wanted to go. So I looked for opportunities, which took a few years for me to start practicing in this area. It's a great
Mm-hmm.
story if we have time of how I ended up in this area because, yeah, if we have time
Oh,
at some
okay.
point, I'm happy to
Okay.
share it.
Okay. Yeah. And especially nowadays with everything being on the internet and so open for everybody to be able to grab something from the internet and take a look at it and be able to maybe claim it as their own or somehow modify it to make it more their own. It's really, really tricky. There are so many aspects for us as printers, and hopefully people who are going to be watching this, most of us all have websites. And when a client gives us artwork to print, they actually one of our guys who also works with our software, Deco Network. His name is Travis Tollefson. He has a web store, and he was asking about what he obviously produces transfers, and then people send them artwork, and then he makes them, and then they create the products. What is our liability when producing transfers for someone who orders online and then they check the box that they agree that they own the copyright? So what is our liability as printers for somebody
Well,
else giving us
that
that?
is a really good question. And I mean, I'm happy to answer that question, but just like overall, what everybody needs to know, which is a huge misconception, that just because something is online and you have access to it online does not mean that you have the right to use it.
Mm-hmm.
Basically, if you didn't create it, you need permission in order to use whatever that is
Mm-hmm.
from the owner of that copyright, what we're talking, or trademark.
Mm-hmm.
Otherwise, you can be liable for infringement. In this case, copyright infringement. Now, you said, Meryl, that in the specific instance when somebody comes to a printer and says, you know, I own it,
Mm-hmm.
and checks a box. I mean, it's great that a company is proactive and has them acknowledge that they have the rights to use that item. But if somebody came to a printer and said that they had the rights to use something that you as a printer know, like there's no way they have the rights to use that,
Mm-hmm.
then just because you have them check the box does not mean that you can't be found contributorily to have infringed. So yes, as a printer, you can be held liable. And in situations like that, it's factually specific. So there's no like, nothing that I can say to you that if you check every box, it depends on the facts and circumstances, what the printer knew, what they didn't know, what was told to them. All of those things would be looked at by a court if somebody filed a lawsuit.
I see. So let's say it's something like, like a Disney logo or a McDonald's logo. Obviously, that's going to be super obvious. But what if it was something like a local school or a brand, like if I decided to create like our Spill the Tea brand. If somebody took that and went, I better not do it because LA is going to get you. If somebody took this and went in I don't know, in Indiana and came up with that idea, and well, didn't come up with the idea, took my idea, and then we found out about it, but the person who's printing it doesn't really know. Is that person, I guess they really wouldn't be get too much of their hands slapped. I don't know. It's
Well,
probably.
again, in this factual scenario, it would depend. I mean, I don't know how widely known, like in the industry, Spill the Tea is, but let's say everybody knows in your industry that you are Spill the Tea, and the logo that's behind you, everybody knows that that's Merrill's, right? Your company's.
Mm-hmm.
And they went to a printer that knew that and knew that this person may not really have the rights to use that image. It would
Mm-hmm.
be incumbent upon them to either investigate further or not print. But here we're talking about also the levels of potential liability, right? Because if somebody came and asked for 1,000 or a large number of t-shirts, right, printed on, I mean, we're getting into commercial, like where they're going to sell them, they're going to commercialize them versus use it for individual use. I mean, it would be looked at a bit differently with respect to that. But to your point, Meryl, the way like you would protect yourself with spill the tea is to obtain a trademark, spill the tea. You can get a word mark, you can get a logo design trademark, as well as a copyright protection on the image. And when I say that, I mean applying for filing applications and applying to get registrations with the United States Patent and Trademark Office and the United States Copyright Office.
Got it. Okay, so that's going to bring me to the question that I think people really need to know, and that what are the key differences between copyright, trademark, and word mark? And how a service mark? I know there's also service mark, right?
Yeah, so happy to answer the question. There's a lot of confusion. So let me just back up for a second. When people say intellectual property falls into 4 categories. You've got trademarks, you've got copyrights, you have patents, and you have trade secrets. Those are the 4 general categories. And to answer your question, when you say trademark and service mark are basically the same thing. And people often say trademark when they're referring to a service mark. Basically, a service mark is when you're using the mark in association with services. You're selling services versus selling goods. But those terms sometimes are used interchangeably, as well as the various areas of intellectual property. So just basically, generally, what is a trademark? So a trademark can be a word, it can be a logo, it can be a slogan. There's also non-traditional trademarks that can be a sound or a color associated with your goods and services. And there's a list of other non-traditional trademarks, but it's basically something that identifies your company as yours, uniquely identifies your company. And when you are the only one using that mark, that's when you can get national, by applying for a trademark registration with the USPTO, United States Patent and Trademark Office, is when you can obtain exclusive rights to use that trademark. And under trademark, as I said, Meryl, it could be spill the tea, the words. It could be spill the tea, the design of the logo. So those are different types of trademark applications, all falling under the umbrella of trademark.
Okay, so if somebody came to you and said, this is what I want protected, obviously you would know whether it would be a trademark or a word mark, and they don't really have to worry about that if they call you and say, hey, I just need this protected.
100%. And those are conversations that I love to have. I love when clients are proactive, or companies, they call me and they want to protect, ahead of the game before there's a problem. That's like the best time. The sooner the better. There's reasons to engage in brand protection sooner versus later, because you can actually get blocked from protecting your brand down the road. But I work with my clients and I help them identify what intellectual property they have and what options they have in protecting. So, for example, one of the things that I didn't say before to the last question, I mentioned spill the tea trademark, but you've got a very creative design there with a cute a cup and a T-shirt in the cup. If you created that, that's also something that we could file for copyright protection on. And there's different benefits. There's different reasons why you would have one versus the other, or have them together.
Gotcha. Okay. Yeah. And I think, like, if we want our customers to be protected, we should be proactive and be protected ourselves as well. So, like, as business owners, it's important that that this print shop in this print shop in Indiana that's going to take my spill of tea, that they should protect their name as well, because there could be other businesses that are taking your name, even though you own a web. Okay, what? Let me backtrack. We discussed this ahead of time. Just because you have a website doesn't mean you own that name. Is that correct? That's a
Yes,
biggie.
Meryl, absolutely. And I'm so glad you mentioned that. There's certain misconceptions, or I would say mistakes, that happen that I hear all the time that people make. And
Mm-hmm.
one of them is, well, I have the URL. I own that domain name. So I have, nobody else can use it. And that is a misconception, because a URL domain name in and of itself does not create trademark rights. By the same token, filing registering your company with the Secretary of State in your particular jurisdiction does not give you exclusive rights to use that name. So there's a number of misconceptions, and just a little plug. I actually did a video on common mistakes. That's on my YouTube channel. So
Oh, okay. Okay. Well, we have to visit LA's YouTube channel, and it's Brand Law Protection, right? Is your
it's
YouTube
brandprotection.law.
Yeah,
Brand
right here in
Protection?
the comments, we'll have a link to your website, to your
Okay,
Wonderful.
good.
channel.
Thank you.
And it has like this logo. If you all see this logo, if you see that logo, that's LA. It's her P, which actually I know what font that is. That's another thing I want to talk about. Actually, Guillermo, you need to ask some questions now. Come on, let's hear from your point of view as a
Yeah,
graphic designer.
well, I would like to know more about the stuff that people can find online and then use it to open a store, because we are talking right now about the big guys, the big companies. Of course, they are going to trademark their stuff because they're big, Apple, Disney, all of that stuff. But for example, if I open a web store right now and start selling with Mega T and Deco Network, and I took something from the internet and make like small changes, but you can know that's from another person. Is that okay? I'm doing something wrong if I do not create 100% the artwork. For example, if I use the same font than other people use.
Guillermo, I think you've asked like a number of questions there. And, the same font, it really is going to depend on what you're doing. Like a font is not something that's protectable. Okay.
Right.
But like, let's say, I'm making it up, Coca-Cola, you know how Coca-Cola has written out in the cursive, its font, right? If
Yeah.
somebody took that and did a similar Coke product and didn't call it Coca-Cola, but did it something that may look like it was associated with Coca-Cola, but it's not, that would be a problem. Really, the best thing is when people are starting a business, you can't take what other people have done and just use it as your own. I mean, like to give you an example, I recently represented a client who is an artist, and she saw online a photographer that had taken a picture of something that she thought was beautiful, and she painted that picture. And she got a lot of exposure on social media, and that artist found her and sent her a cease and desist letter. That's infringement. Now, if she in her house, if she just painted it and hung it up in her house and wasn't commercially selling it, that's a different story. But here she was looking to monetize it. And that's, what a lot of these issues come down to. And you're talking about actually having a store set up. It's really important that you have rights to whatever it is that you're selling in your store. I mean, I can go on and on and on with examples.
I didn't know about that, the drawings. If I took some picture and I make my own drawing based on that picture, I didn't know that. And I like to draw, and I was thinking of open a store with my drawings, but I draw based on a reference. It's not 100% of came up of my imagination. So
Mhm.
I didn't know that.
Yeah, and that's really comes down to whether it's going to be commercialized or not. I mean, all of these cases turn on the facts, whether they were available, whether they were sitting there copying it, how they came up with it. Could that person have independently come up with something in their own mind to paint something? I mean, all of those things would be looked at and researched to determine liability. But liability, I mean, if somebody gets caught, so to speak, using something that they shouldn't be, infringing on somebody else's copyright, I mean, it can be very steep penalties. And oftentimes it's copyright and trademark.
For example, you said you placed the example of Coca-Cola font, right? So if I took that font because it's online somewhere, and I create a text, for example, if I do a mashup and instead of Coca-Cola, I will say, I don't know, Pepsi-Cola. So, but with Coca-Cola font, is that an infringement? Is I'm
Fonts cannot be copyrighted. So,
Really? That's interesting you said that, because when we download fonts, there I mean, we go to certain websites to download fonts. Adobe has fonts that we subscribe to Adobe, so we pay to have the rights to use these fonts and also pictures, which I'll ask you about in a few minutes. But I thought that if somebody created a font, like let's say the Disney font, there's something called Waltograph, and people use this all the time for their Disney inspired t-shirts, even if they're not going to put Mickey and Minnie picture on there. So you're saying that we are allowed to use a font that looks like Disney, or we're not allowed
I
to use?
can't really answer. It depends on how it's going to be used, and just
Okay.
I want to make a point. We're talking generally about everything right now. I'm a
yeah.
lawyer in the state of Florida. There's
Right.
particularities depending on where you are in the country. Some courts view things a little bit differently, but they're definitely general principles. And we're talking generally. So if anybody is listening to this and you've got a situation, please don't take like whatever I'm saying as gospel related to your situation, because it really needs to be looked at and evaluated uniquely to you.
Right.
Okay.
So Meryl, to
Yeah.
answer your question, the actual font is not copyrightable, but it would be depending how it was used. I mean, if it
Okay.
was used in a manner with certain images, it would depend. Just taking the font in and of itself, right, it would not be copyright infringement because fonts can't be protected. Now, if there's a program that creates a font, a specific program, that's something that could be copyrighted, like the software that creates the font.
Oh, I see. I see. So it sounds to me like what you're saying. Like, let's say we did spill the tea in Disney font, it's not going to matter. But if I did Merrill or something like that in the Disney font, and I tried to sell that as a Disney alternative, that could be
Oh, that's a better way to
a
explain it.
bad thing to do.
It could be if it's something that would be construed by the brand owner as
Mm-hmm.
something that creates confusion with
Mm-hmm.
respect to their brand identity.
Mm-hmm.
In other words, somebody would think that there was an association between you and Disney by virtue of what you were doing.
Uh-huh.
It potentially is problematic, but there's parody. Parody sometimes is a an exception to infringement, and sometimes we've got fair use if we're using it for educational purposes and non-commercial monetizing purposes. It's such a heavily nuanced area. These
Right.
are great questions,
Right.
but it's really fact and case specific.
So there's a lot of DIYers that are out there, like a lot of people, very, very super creative people. They're doing all kinds of stuff, tumblers and all t-shirts, and and they're not doing large quantities, or they're doing a little bit, but they actually post things on their community Facebook pages where they're showing these different, like, Marvel comics and different things like that. And I look at this stuff and I'm like, I want to scream like, oh my God, you're not allowed to do this and sell this, to your PTO or to your, to the business down the street. You're not allowed to do. And I haven't like stepped in and said like, hey guys, that's copyrighted. You can't really do that because I don't know exactly what they're doing with it. And I don't want to, but I want to like I got to put our podcast on those sites so they can see that, because it's really, I mean, I think it's pretty rampant out there. And I know that with people really need to understand, you can use like a Google Lens and you can find anything that somebody posts on something. And the more people are posting that they're selling these things, the more Google Lens is going to pop it up, and people like like you are going to find this for your clients that are going to get them in trouble. So, I mean, you really got to watch it, guys. You really got to watch it and be really, really diligent for you work really hard for your businesses, and you don't want the businesses to be taken away from you and your family and your workers and whatnot, just because like making some extra money on some of these products that you think everybody likes. It's kind of crazy.
Yeah, indeed. These mistakes really can cost, as you say, Meryl, a lot of money, and cost somebody their business.
Mm-hmm.
What you're saying is, unfortunately, I see that all too often, where a small business owner comes to me and, in tears because they received a cease and desist letter from a large company that's got a lot of money behind them.
Yeah.
And they're upset because they're, a very well-known brand, and, they've got a store online where they've been selling goods that aren't authorized with that company's brand. Where, I've seen letters where they are asking for millions of dollars. And just so everybody is aware, I mean, the penalties, depending on the significance of the infringement, can be really extreme, like in the millions of dollars. And jail time is a possibility too, depending on how egregious, if we're talking about counterfeit trademarks, where somebody's basically made up something to look like one of the luxury brands, and is printing that on a t-shirt and doing that in volume, that's a problem.
Right. Guillermo, what did you say that when you were in school, your teacher told you about?
Yeah, most of my teacher told me that everything is created. Don't worry about create something new because everything's been done. So just take something and make it your own. Not making your own in the way that I take it from the internet and it is mine now. No, I take it from the internet. I took it as an inspiration and create something based on that.
Maybe. It depends.
Yeah, I know. That's
it depends on
my
what we're
experience.
talking
I'm not.
about, right? Like sometimes
Yeah,
you can read a story and the story
yeah,
inspired you to write something. You didn't write the
yeah,
exact story, but it inspired you to do something,
yeah.
right?
So we had talked about this before, and this is like something that, again, I like want to pull my hair out, is when I see people come to us, and I'm sure to all of you guys that have print shops, that they purchase a design from Etsy and then they want you to print it. And beyond a shadow of a doubt that it is a licensed image. Now we were talking about this, there are some companies that actually obtain licenses to print certain, say, cartoons or certain TV shows or whatever, that they have licenses to print specifically a product like a t-shirt, or they can get a license to print a keychain, and I know that this is a pretty big thing with the NFL. So maybe you're licensed to print shirts that have a sponsor logo on it, or you and you pay for these licenses too. So if you haven't written that check, then you can't do this. But when somebody comes to you, that the artist created the birthday invitation for Mateo's 5th birthday party, and it has Spider-Man on it. should a business person approach that?
Well, a business person needs to make sure that they're paying for the licenses that are necessary to do what it is that they're seeking to do. So there's different types of licenses. It's not like one license fits all. I just this morning was having a conversation with someone who was telling me they were setting up a platform, and they were talking about Canva, and they said to me, "Oh, I'm using a free license," and now she's setting up a business. Well, now I'm not familiar with, I don't represent Canva, and I'm not familiar with their terms and conditions, but just generally speaking, a company, for example, may provide someone with the ability to use something as an individual license for free. But I'm 99.999% certain that if that person then looks to commercialize it in some way, use it with the masses, and they're using it now for their business to promote their business, more than likely there's a licensing fee that would be required. So it depends on what, the company is doing or the printer wants to do. But, it's, unless it's in the public domain, when once a copyright has expired, and that, if it's generally speaking, depending on when the copyright was obtained, but generally speaking, it's the life plus 75 years. If we're outside of that period and it's in the public domain, then it can be used. However, I say that with caution because trademark protection doesn't necessarily expire if it's maintained, if the person has continued to use it. So if it's protected both ways, just because it's available by copyright doesn't mean you're free to use it, because there still may be a trademark protection.
So I have a good question then. What about something like the likeness of the David statue that was sculpted, a really long time ago?
I wish, Meryl, that I could tell you that I knew off the top of my head when that was sculpted, because I don't know. I don't know, what 1600s or where we're talking about with the David statue, but it's likely that that's in the public domain.
Okay. Is there
but don't quote me on that.
Okay.
Maybe they improved maybe somebody improved on the statue.
Well,
and
I know
it.
something that goes. It went recently to the public domain. The Winnie the Pooh story and characters that went public domain recently.
Really?
So
Okay.
yeah, and there's a crazy movie right now that make Winnie the Pooh like the serial killer.
Oh.
And I know that, so right now that's in the public domain, right? I can create a Winnie the Pooh t-shirt and sell it.
Well, I don't know that myself, Guillermo. Maybe the story's in the public domain. I'm not sure
Okay.
if the character's in the public domain, and there's a
Okay.
distinction, right? The Winnie the Pooh story maybe, but the characters, I would be willing to guess.
No, I think the characters know. Yeah.
Yeah, they're probably still protected.
Okay.
Is there a website to find that out? Is there like a public domain website that you could type something in and say, how do people know that?
I am personally not aware of like a website that's, doing all of that. There may be something out there that's tracking for when things are in the public domain. I know there's some websites that are available, which have information or copyrighted material that the owner of the copyright has said, I'm allowing this into the public domain. Everybody can use it, but if you're going to use it, you need to give credit, and they give a specific way in which credit needs to be attributed to the owner or the creator of that copyrighted work. So there are websites where you can find royalty-free or licensing-free copyright material. I mean, even on like the Shutterstock and the big websites where you can get images, they have royalty-free licenses available there as well. So, I mean, it's definitely available. Probably a good business concept for anybody that wants to congregate all the information in
Right.
one spot.
So
Right.
I asked you about free stuff. Now I'm going to ask you, you mentioned Shutterstock and all the similar websites like Adobe Stock. If I bought image from one of those places and make it on my t-shirt, I have rights to use it and sell a product based on that, right?
Not necessarily. It depends what rights you're purchasing. You
Hmm.
know,
Yeah, I know there is levels of licenses for
right. So
those
if
image.
you purchase, like, let's say there's an image
Yeah,
and whatever, it says $50 to purchase this
yeah.
image. And once you purchase the image, you own the rights to reproduce it, to use it as you wish. Then you're free. But make sure if you're going to do that, keep a file with
Okay.
confirmation of how you obtain that license and the payment if anybody comes back to you to challenge it down the road, that you have access to that you actually purchased the license.
And that's my next question. If somebody does the same and see my store and say, "Oh, you have the same design, just remove it because I have this image and I have the licenses," and we both have it, so it's okay. Nobody wins, and
I guess I'm not 100% sure what you're asking. Are you saying if somebody sets up a store similar to yours, they bought the
yeah,
same image
yeah,
from from the same place, they have the same thing.
yeah,
Okay, so this is where we were talking about like branding and trademark protection. So what you would need to do to protect yourself, so let's say you bought a really creative image, right? That it has become the trademark for your business. Well, you want to
yeah.
make sure that you protect that by getting a federal trademark registration. And once you have that, you can stop other companies from competing with you using the same thing and causing confusion and taking business away from you.
So
Okay.
how hard is that, and or how long does that take to get done? So we come up with an idea for our business. We have a business name. And also maybe our clients will come into us. We could actually offer your services as a service to our customers too, correct? Like how
Well, I mean, I'm happy to have referrals, Meryl. So thank
okay.
you.
Okay. So but I mean people come to us as printers with these like awesome ideas, and sometimes they leave and they're like, that was a really great idea that they shared. It would be great to offer them the ability to protect it, or even the opposite. The customer's like afraid to tell us about their idea because they have this great idea for this business and they give us a logo. So how difficult is it, or not difficult is it, to actually protect ourselves or our customers as well?
Okay, so let me, great question. I can just speak generally about the trademark process. It's a process that takes, depends on how busy the trademark office is at the time. But like right now, it's taking between 12 months and 18 months to go through the cycle of the trademark application process. And that's, assuming that we're not running into major issues, because if somebody files for a trademark application, and this happens a lot with DIYers, they believe that they can do it on their own and they file a trademark application. But what they didn't do is they didn't do a comprehensive trademark search, and they didn't realize that the trademark that they are seeking to get would infringe another company's trademark. And when that happens, there could be an opposition to the trademark that then it becomes more expensive. And depending on the facts and circumstances, they may be totally blocked from being able to get that trademark registration. I always, as you know, when people are starting a business or even in business, before they are going to file a trademark application, generally speaking, it's always a good idea to engage somebody with experience to conduct a comprehensive trademark search, because that comprehensive trademark search really gives a company an overall of what is out there that is the same or confusingly similar to the business that you're going into wanting to use that trademark. And that will inform, well, do I still want to continue using this trademark? Do I have the ability to get a federal trademark? It'll inform those sorts of things. And I want to make a point on something, because there's certain things, like there's a continuum of the type of marks that would be protectable. So the kinds that are, the made up words or the words that are used that have nothing to do with the type of services that you provide are going to be the strongest kind of trademarks. Like if you say T-shirt printing company,
Mm-hmm.
you're not going to get exclusive rights to use the name T-shirt printing company, because it's describing the service that you're providing. And if you got that, other people couldn't say T-shirt printing company.
Got
right?
it.
Right.
And so that's another thing that I also love helping clients with, is like understanding, like when they're going to brand something, is the strength and the likelihood and the options they have with respect to brand protection based on their name.
Mm-hmm.
Now, a creative logo can help them get past that, right? Because you could still be the printing company of Palm Beach County or whatever, but you came up with a really creative logo that's unique to your business. That can be protected.
Mm-hmm. So when somebody has that, and you're saying it takes about 12 months, should they not use it in that time period? Should they hold off on launching their business or launching their brand until?
Not necessarily. That's another great question, Meryl. Not necessarily. When you file a trademark application, can be filed in different ways. You file it as something called an intent to use application, and you can file it, where you're already using it. The benefit of an intent to use application is when somebody they're putting together a new business and they're working behind the scenes and they intend to use this name and they want to get the process started so that they're further along in the trademark process. And then when it comes time to file, what's called a notice of allowance. Like, okay, this trademark is approved, but it's subject to the owner now presenting evidence of using the trademark in association with the goods or services that they're seeking to use that trademark with.
Mm-hmm.
So to answer your question, I think, and the best thing for somebody to do before they go forward and just use a mark and spend a lot of money in marketing and advertising is to do a comprehensive trademark search, because that is going to inform whether or not you file a trademark application or not. Are you subjecting yourself to liability? Because if you go forward using a name that is confusingly similar or the same as a competitor in your industry, I mean, the damages, you could be subject to whatever money you make, you have to turn over. You have to turn over all your profits. You can be, liable for attorney's fees. I mean, it could literally shut a business down.
Mm-hmm. Mm-hmm. I it's funny because we do a lot of work with nonprofits, and through the years, I have seen nonprofits have some similar names because, let's say, they're doing a similar thing that they're helping, working towards their mission. They have similar missions. Usually it's helping people do something, and sometimes they'll spell it a little bit differently. But there has been a lot of confusion and with certain nonprofits, and I'm sure with businesses as well. So let's say one nonprofit isn't doing such a great thing, and then you come in and they think that this is your nonprofit, and colors could be the same. Like with breast cancer, it's always pink. And so there's a visual thing that's going to kind of look similar. I guess it's really important to make sure that your name is protected so somebody else doesn't come in and do something bad with your name.
100%. And Meryl, this is so on point because I'm literally helping a nonprofit right now that has a situation where they didn't file a trademark application, and a bad actor that's looking to do something similar and create confusion beat them to it. There's still things that they can do, but it just makes the process now more expensive and difficult.
Right. And one thing that is so precious is time. You can't get that back.
No.
And
100%. Yeah, absolutely. Not only is it the attorney's fees, but it's taking people away from their businesses. It's the stress of having to deal with a dispute. I mean, litigation is not generally a fun experience.
Right. So sometimes you spend a little time, spend a little money ahead of time, and it protects you in the future for anything that's really going to just knock you down.
Penny wise, pound foolish, right? As the old adage goes.
Right. I don't think I've ever met an attorney that has a marketing brain also. So
No.
you are very, very special.
Well, thank you. You're making me blush. I appreciate the acknowledgement for that. Thank you.
I mean, and the fact that you understand so many different types of businesses, and which is really, really, that just adds to your checklist of your abilities. So that's wonderful. We were talking before we were on about colors, and we were mentioning about like the colors, like the Tiffany logo is a certain blue, and I know that Pantone is the color chart that we all use all around the world. And so besides just like in the US, if somebody comes up with something like Target stores has the red, I guess the word Target can't be copyrighted because it's a word, right? But the logo,
there's a trademark. There's a trademark. I haven't for Target. I would be willing to bet that Target has trademarked the word Target for their stores, as well as their logo, the bullseye logo.
Okay, so somebody can't use Target, like I mean, it's a word, like Target.
Somebody, I'm going to explain that. I'm sorry, I didn't mean to talk over you.
Okay.
Somebody could not set up a store that looks like Target and has, or even an online presence or a brick and mortar store that sells the type of goods that Target sells with the word Target on it. That would be trademark infringement.
Okay.
Now, I could potentially, I'm trying to, think, a new line of something up like a storybook, or I'm a publisher and I'm going to call my publishing company Target Publishing. It's so so this leads me to an important point. So when you file for a trademark application, you have to specify the goods or services that it falls under. And there's a number of, and it's called international classes of goods or services. So like if you're a retail store, depending on what you are, a publishing company is not the same as a retail store. So you could have the same name as long as you're in totally different like industries, you're not competing with each other. There are situations though where the brand owner could say, no, this is still confusing. Somebody would think it's there's an association. But generally speaking, you can only protect when you're filing a trademark application, you're protecting it relative to the goods or services that you're selling, not like everything.
Okay. Got it. In marketing, people would talk like you should really call your company something that is what you do so that people know when you come in here, like Make a Tea Online, they're going to make a tea online. But then you have all these other like t-shirt stores online that have all these like Redbubble and there's like these, like that has nothing to do with t-shirts, has nothing to do with product. But you were saying that if it has nothing to do with the product, then that's different than if it really is exactly what your product is for being able to trademark it. So Redbubble could be trademarked as a t-shirt company as opposed to I make t-shirts.
Right.
Print on demand company.
Sorry, Guillermo, what did you say?
If your name instead of Redbubble is going to be like print on demand company.
Right.
Now, if it's print on demand company, and you wrote that in a really creative way with a very creative logo around it, you could file that logo. The United States Patent and Trademark Office would probably say, okay, you can have potentially a trademark on that logo, but will say that you don't have exclusive rights to use the name that you put in there, the print on demand company, for example, because that's just a description of, so somebody could use it, but they can't use it in the form in which you're using it.
Right.
I've got a wild scenario to throw out there. Okay, really wild scenario. Okay. Let's say somebody comes into our shop and has one of these like a Disney logo or something like that and asks us to print something. Does Disney or these other people who have big brand names, whatever, do they ever send out people to test to see if you're going to like take the bait and print that logo?
I think that does happen sometimes, but it's generally, just think about, where they're going to spend their resources. Like if they get wind that there is a printing store and that printing store is printing, whatever the brand is, repeatedly printing, Gucci, like the logo, okay? Yeah. For example. And they're just printing it on shirts and, one after the other. And the brand gets wind of that. Yeah, they will have people come and probably order a T-shirt with the Gucci on it so that they have evidence that you actually did that. So to answer your question, yes. If it's a one-off, I mean, it's possible, but chances are, you're not getting the attention of the brand by doing a one-off.
Okay. Yeah, because sometimes I get like nervous with these people that they come in and they ask for things to be printed. And like, who are you? Are you being sent from, the manufacturer of that brand? I don't know. I worry. I don't want to be shut down. I worry about things like that.
It's good to be concerned about these things and not just like put blinders on and say, here, sign a release. I can do this, where as the owner of the print shop, that probably not.
So Guillermo and I created a bunch of T-shirts for something that it was a project that we were asked to do, and we used Adobe stock for our base for the images. It was an old master's piece. That's why I'd asked about the David statue earlier, and it was this old master's piece, and we used the base images from Adobe stock, which we pay for. So we are able to use those. We didn't sell the products, by the way. And then Guillermo added special touches to them to make them unique. So some of them were, it was like Pablo Picasso was one of them, and Salvador Dali was one of them, and the David statue was one of them. And we posted it on Instagram. We posted on Instagram. We didn't sell them, but we have them as samples, and we were just showing unique print methods on these specific Gildan hood sweatshirts that we were doing. It was us doing it. It wasn't Gildan. Gildan had asked us to decorate them, and it was our choice of how to decorate them. So I guess that's so it sounds like what you're saying is that's okay because we didn't sell them. Because I don't remember Guillermo, do you remember what rights we purchased when we had grabbed that?
The regular license that we can use it. I don't remember if that's a specific.
Okay, we need to check.
Sale. Yeah.
You all need to check your Adobe stock licensing and see which licenses you download, because I do think that there are a few that are on there to download when we're going to be using these things. Now, if somebody wanted to buy it, I guess we would maybe have to purchase another license, but we altered it. So I guess my question is, I guess there's a theory out there in the printing world that if you change something 20%, it's okay. I mean, you've heard that, right, Guillermo?
Yeah, yeah.
Yeah, if you
Yeah.
change it 20%, it's okay. But
I
I
don't
don't.
think, yeah, I don't think that that's across the board necessarily. It's really going to depend on what you're talking about. Generally, if you're taking somebody else's work and you're going to use it to monetize,
Mm-hmm.
even if you change it,
Mm-hmm.
it's risky business. It's risky business.
Mm-hmm. How does that translate to other countries? So, like, I know that we're in the U.S., but let's say there's a business in England, in London, and they're using the same software with the same, check the box off and all that kind of stuff. Um, how does that work for other countries?
Well, intellectual property protection is country specific.
Okay.
So, for example, if you're a business owner that's doing business in the United States and then doing business in the UK or other countries in Europe, you want to make sure that you're protected in those specific countries separately and apart from the United States.
Mm-hmm. Okay.
Because it's not like once you're in the United States, you're just protected all over the world. It doesn't work that way.
Mm-hmm. So how do companies like Etsy get away with having putting licensed products on their website?
Well, I really, and I don't want to necessarily speak specifically about Etsy, right? Just generally companies that provide platforms for people, and that those people end up selling unlicensed goods on their platforms.
Mm-hmm.
That's where it's the responsibility of the owner, the companies that own that intellectual property, to file takedown notices with the platform provider saying, I own this, this is unauthorized, they don't have access to it.
Mm-hmm.
I've had lots of people that contact me that have had that scenario occur.
Mm-hmm.
And, sometimes it's true, sometimes it's not. But if
Mm-hmm.
it's true, then it's going to get taken down. And if your whole shop relates to infringed goods, your whole shop can be shut down.
Yeah.
Um,
You could lose
and so,
everything.
I'm sorry.
You could lose everything.
Uh, Absolutely, you can lose everything. So somebody files a takedown notice, you have an opportunity to respond.
Mm-hmm.
Um, but if you respond and you challenge it and it's not really true, you can end up in court because the brand owner is going to need to file a lawsuit to make
Mm-hmm.
sure that that information does not continue to be infringed upon.
Mm-hmm.
But
Okay.
oftentimes, someone who's infringing, hopefully, if they speak to a lawyer, don't ignore those notices. Don't ignore when you get a cease and desist letter. Definitely speak to a lawyer about it that can help navigate and help, deal with the situation. The worst thing to do is to ignore it and think it's going to go away, because that's when problems just get bigger.
Right, right. I had a preschool, maybe not pre, no, it was a school. When they moved into our county, Broward County, they sent out letters to all the print shops. Do not use this logo unless you're contacted by somebody at the school. And this was the only letter we were going to get. And I thought, wow, I'm glad I opened up the letter and I posted it on the wall. And I was like, this is really like very proactive of this school to do this, because you could get people coming in to ask you to put their school logo for their child. They don't want to go buy it at this special store, whatever. They want to do it, privately. They think they're going to whatever get a better job. Probably they would, but yeah. So that was really good that print shop did that, and I think that as printers, we should be able to offer some services to our customers that are able to protect them. I think it would elevate our business and it would elevate us in the eyes of the consumer. So that's a really good another marketing advantage for us to be able to use LA services and offer that to our clients as well. So I think it's great. It's great that we're all meeting you now and knowing what you do and protecting all of us. Um, is there any? I think we've already talked for an hour. It's been
Yeah,
like an hour already. Yeah, and this
yeah, 1 hour.
yeah, Guillermo, do you have any like last questions? Because I know that LA's really
Um,
busy.
well, I think I asked everything I have in mind. I just want to know, about AI, artificial
Mm.
intelligence right now, AI-based image. I read somewhere that you cannot copyright artificial intelligence image. I don't know if
That
that's
is
correct.
that's a great, AI is the hot topic, right? So and it's new and evolving. The case law is like, coming out. It's a new area, um, for the courts to interpret. But you are correct, Guillermo, that AI has been found, if something is created through AI, that it's not protectable through copyright. Um, I suspect that as time goes on, there may be ways and around that, depending on, well, I'm not the court, but where we are right now is yes, using AI does not make you the creative author of the goods and the owner of a copyright. You're correct.
Wow. Wow. So don't ask AI to design your logo. Ask
No,
us. We will do it for you.
yeah, it's better.
That is what
Now
we.
that's a bit different, just so you know, that's a bit different, Meryl, from copyright registration. Because if you asked AI to design a logo,
Mhm.
and you use the logo for your business and it's unique and there's no competing business that's using the similar
Mhm.
image, you could still use that for your branding. You just
Okay.
can't get a copyright registration as being the owner, you uniquely own it and created it. So it's
Right.
it's it's different rights.
Uh-huh. Got it. Got it. Got it. Okay. Okay. Well, thank you, everybody. Thank you, friends, for joining us. For whoever's going to be watching this later, please leave nice comments. Please subscribe because, as everybody else says, it helps them. So hopefully it'll help us. I'm not really sure how. This is new for us, this podcast, but you can also view it on spillthetea.live. And we are going to be having merchandise on there. Actually, I think there's a couple things on there now, but we have to work on that. It's a constant growth and constant change. And if anybody has any questions or wants to get in contact with LA, please write something in the comments. Check out her YouTube channel. I think she probably has already written down a couple more topics to make your YouTube videos about now. And
Yeah,
we are so happy that you joined us. And thank you, LA. You
thank
are
you, LA.
wonderful. You're a wonderful treasure. And I think we're going to be best friends.
Oh, wonderful. Thank you so much for having me. I've really enjoyed this conversation and the opportunity to speak with you. Thank you.
Okay, you're welcome. You're welcome.
You're
All
welcome.
right, well, bye bye for now, everybody. Take care.
Bye.